Okay, good morning, everyone. It looks like we're up and running here. Welcome to the March docket of the Kansas Court of Appeals. I'm Judge Thomas E. Malone. We also have Judge Gordon Atchison and Judge Sarah Warner. We will be the panel of judges for today's cases. We have 3 cases this morning, and I'll call them in the order of the published docket. Just a little introduction, counsel, you probably understand, but we have read your briefs. So we're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your presentation this morning. As presiding judge, I'll be the timekeeper. Each side is given 15 minutes for your argument unless it's designated differently on the docket. The appellant's attorney should let us know at the beginning of your argument if you wish to reserve any time for rebuttal. And after the arguments this morning, your case will be deemed submitted for decision. And after that, we will take the case under advisement and get a written decision out to you and your clients just as soon as we possibly can. So with that, I'll call the first case on the docket. It's from Marshall County. It's number 124032, entitled Judith Claeys, trustee versus David and Kenneth Claeys. And for the appellant, I understand we have Mr. Robert Kuykendall.
It's Kirkendall, and that's correct, Your Honor.
Kirkendall. And for the appellee, Mr. Andrew Lohman.
That is correct, Your Honor.
All right, Mr. Kirkendall, do you wish to reserve any time for rebuttal?
I would like to reserve 3 minutes.
That is granted, and you're ready to proceed.
May it please the court. In Miller versus Miller, the Kansas Supreme Court reversed a district court in a partition action for not awarding a co-tenant who was responsible for improvements to certain land credit for his contribution to those improvements. In this case, the appellants, David and Kenneth Claeys, were responsible for improving farmland, changing it from unirrigated cropland to irrigated cropland. But instead of following the Miller rule, the court below awarded the appellants no credit at all for the improvements that they brought to the land without the plaintiff's participation. The court
in looking at Miller, I was sort of fishing around for a definition of improvement. And I'm not an expert in real property law, but it commonly seems to me it's something that is attached to or in addition to the land, not necessarily a fixture. But in this case, do we have something that constitutes an improvement in the Miller sense?
Yes.
And if so, what is it?
Yes, of course you do. Well, what you have is you have both the water right, which becomes a property right tied to the land, as well as the infrastructure that permits the irrigation to work. You've got something called the point of diversion. It's diversion works that allow you to collect the water from where it is. In this case, it's from the stream. You have underground piping that pipes this water from that location to the center pivot location, where then it can be distributed. You have electric cables that are buried, that are become part of the land, that are associated again with that system. But I would say,
Counsel, you're not contesting the district court's finding that the pivot system was personal property, are you?
no, not at all. Not at all. That's not a question at all. And we aren't seeking any compensation for the pivot system. The pivot system was our personal property to begin with. It wasn't valued when the property was valued, and it's ours still afterwards. We aren't seeking compensation for the pivot system. What we are seeking is the value of the improvements that we brought to the land.
Counsel, just along those same lines and looking at the pretrial order, it looks like the single legal issue that's listed in that pretrial order frames the issue in terms of the value added by the pivot system. Is that different from how you're framing the issue now?
Not at all. Not at all. You got to understand, Your Honor, that you cannot separate the personal property. Well, you cannot separate the two aspects that are required in order to obtain a property right to use irrigated water. And those are, first, you've got to be able to have the legal right to irrigate. And to do that, you need to appropriate and actually use the water. So, you need both aspects. The personal property is an investment necessary in order to secure the legal right to use the water, which is essentially the thing that increases the value of the land.
Now, but the pivot system itself wasn't necessary. It was just some action to divert the water, correct?
A system was necessary, whether it's the pivot system or some other system. And this whole structure was built to accommodate a pivot system. So in essence, to obtain the right to irrigate this 126 acres, you needed to have a pivot system. That's the whole structure is built to accommodate that.
So as I understand, no, go ahead.
No, go ahead, Your Honor.
As I understand it from the briefing and looking very quickly at the statutes, the water permit that Kenneth Claeys secured attaches to and runs with the land, essentially. So if the land were sold, the permit would go with the land?
Correct. Correct.
Does it exist in perpetuity so long as the water is being used?
Yes. Yes, it must be used in order to be perpetuated.
Right, but it's not like a permit for 10 years so long as you're using it, or 25. I mean, there's no outer time limit.
No, it's in perpetuity as long as it's used. But again, it must be used in order to be maintained. And to use it, you do need a system. And that, in this case, was the center pivot irrigation system, whether it's the one that Kenneth Claeys had or another one like it. You need
what do you see?
System.
What do you see as the remedy here, if you're correct in your argument? I mean, what are we supposed to do?
Your Honor, I think the remedy is you reverse the decision of the court and you remand to the judge to make a determination as to the value of the improvements caused to the land by changing it from non-irrigated to irrigated. The evidence below gave a range of values from $700 per acre all the way up to $2,800 per acre. Now, we believe that the case law of Kansas, especially in condemnation cases, require that a finding of value be within the range of the evidence. So the court needs to decide the value of the improvements within that range. I'm sorry. Either from $700 per acre up to $2,800 per acre. I think you need to reverse the decision and remand to the court with instructions to determine a value within that range.
Does the district court, acting in its equity capacity, have actually broader authority than that, or is it confined to some dollar amount that somebody said the improvement to the land was worth? Or are there other considerations that figure in the equity jurisdiction?
Well, normally I would say, Your Honor, that there are other equity considerations that may, in some cases, be present that would require a different conclusion. But there's no indication that there are any kind of equitable considerations in this case that would require any different conclusion. And the court didn't cite any different equitable consideration in making its determination to award nothing. In this case, I don't think that there is a reason given that would justify a departure from what's clearly established as the Miller Rule.
Counsel, I want to talk a little bit about that Miller Rule just for a second, because as I read the Miller decision, there are a couple of holdings that come out of that. One is that the partition is the general rule, right? So that if in Miller you had a person who had purchased the house, and then you had that person who had deeded essentially 1/3 equity in that land to two other people. And so the rule that came out of that was that you had to partition that 3 ways, despite the fact that one person purchased the house. But then there's this other statement, and this is what I think you're relying on, that a court may decide that improvements should be the subject of a credit. But it doesn't say that a court has to decide that improvements are the subject of a credit, does it?
I would suggest, Your Honor, that it does. It reversed the district court for failing to consider whether a credit should be granted.
And then Miller isn't our last decision on this, is it? I mean, we have another decision in Denton versus Lazenby that articulates the fact that the Miller Rule, as it had been come to known, was something that arose. It wasn't a legal rule. It was something that arose out of the balance of the equities. And so I'm just wondering, is it a rule, or is it something that the district court can take into consideration but doesn't have to?
Your Honor, I would suggest that it is a rule, and it is founded, as we cited in our brief, upon principles of equity that extend back to the founding of the state and beyond. It's the idea that a person who invests their time and effort in a project is entitled to reap the benefit of the investment. And that is a basic principle of equity that was in the Kansas statutes from the beginning with the Tenant Improvement Act, and has been uniformly applied throughout the time. I would say that it is such a basic principle of equity that it is a rule, and if you're going to depart from that rule, you need to provide at least some reason as to why that rule doesn't apply. And in this case, there is no hint by the court as to why the Miller Rule doesn't apply in this situation.
I'm curious. I have one more question, and then I would like to hear the remainder of your argument. But I'm curious, in looking at the court-appointed appraiser's valuation of the land, in this case, it's a valuation that just provides a lump sum value. It doesn't provide any kind of a breakdown as to how the appraisers arrived at that value. And does that change our analysis or the calculus in determining what the appropriate credit, if there's any credit to be added, what that credit would be?
Well, first of all, Your Honor, I disagree with your belief that the appraiser's value was simply a number. One appraiser did a full written appraisal of the property. And in that, he specified what values he assigned to different tracts, including the 126 acres of irrigated land versus the other land. And in this case, because it wasn't really an issue in just dividing the land in 3, we had the appraisers enter the courtroom and testify in our credit proceedings as to what they viewed the increased value because of the irrigation was. So they testified, 700 an acre or 800 an acre. And one had a different appraisal that came up with $2,800 additional value caused by the change from the non-irrigated to the irrigated. So I would not agree with your characterization that the appraisers didn't come up with a value or a differential in value.
And is the appraiser's report in the record?
Yes, Your Honor, it is in the record.
And where is it in the record?
I will find it. It was cited, but the testimony and the conclusions of the appraiser.
And looking at that, I'm not looking for the individual reports that the appraisers did in preparation for trial. I'm looking for the report of the court-appointed appraisers in reaching the valuation that was agreed on and accepted by the court.
The single page report is a summary report, and it does state a value. You are correct in that. And it concludes just to the value. But how they got there is spelled out in the trial that we had on the credit issue.
Thank you.
Counsel, I'm afraid we're already into your rebuttal time. So if you want to reserve that.
I'll reserve the balance of my time.
Okay. Mr. Lohman, whenever you're ready to proceed.
Your Honors, in court, in this case, the district court properly determined that the defendants failed to show that they were entitled to a credit for any improvement to property. The first issue,
Mr. Lohman, before you get too far into it, do you agree that there was in fact an improvement to the property as a result of the acquisition of the water permit and the equipment to irrigate 126 acres? Is that an improvement?
I wouldn't say an improvement. It did increase the value. I mean, without a doubt, the permit did increase the value, as all the appraisers testified to.
Okay, why shouldn't that be the subject of a division in equalizing the value of the land in the partition proceeding then?
Sure. So in one issue is that with the Miller cases, they did have they were all structures. The Miller and the line of cases were all structures. The problem with just separating dividing the increase of the value would be that basically the costs and effort to get that water permit is not at all equitable to that division of basically $2,000 to $700 per acre increase. That would be one reason why that shouldn't be just considered the improvement to be divided.
What is there some support in the law for that you could point me to, other than it benefits your clients in this case?
Sure. So the way I would see it is, so there's the Miller, and then I forget what the other case was called. In the Miller line of cases, it says if the court does credit, it's limited to the improvement of value. And whereas in the other line of cases, and that's if it's just unilaterally done. Whereas you get an increased benefit if everyone agrees on it. And it's, I guess, sorry, what was the question again?
I'm not sure I remember exactly. It's something you're sort of suggest you agreed that there was an increase in value. But then my question was, okay, given that, why shouldn't that be apportioned to equalize the value in the partition proceeding? And you sort of said, well, I mean, getting the water permit didn't cost anything and there wasn't much effort to it. So really there shouldn't be. And I think my follow-up question was, well, what authority is there for that other than it benefits your clients? I mean, is there something that sort of says, okay, if it doesn't really cost very much? And I mean, the follow-up question would be, what if it were a rezoning? I mean, what if Kenneth went to whoever and got a rezoning at very little or no cost, but it increased the value of the property? Does he benefit from that? I mean, I guess I'm not sure I understand why, simply because getting the permit was of nominal cost, but clearly increased the value of the land, that shouldn't be taken into account somehow.
Sure. So it would be based just on the equities under the partition.
Well, yeah, but I guess I'm struggling as to how that's equitable. And I'm asking if there's some authority that would suggest what you're saying is in fact equitable. If it's a nominal value to get the thing that increases the value of the land, then you shouldn't get any credit for it.
Sure, and I don't believe there's any case law out there on that, on something that's.
What does that say about the rule then, or the argument you're suggesting? I mean, it doesn't, on its face, it doesn't seem very fair. And equity is about fairness. I mean, why is that fair?
So, like I said, I don't think we would dispute that if we had to pay half of the permit or the permit application, that wouldn't be equitable. That probably would be equitable if we did pay half of that. But to give them the windfall of basically that this property was located by a river, and then they just required this permit, and it increased by I think it could be about $100,000 to Kenneth, who was the one who did all of the majority of the work on this. That would not be equitable.
But counsel, isn't it true that under this case law, we look not to just the investment, but the amount that it increased the value of the land? And so it's not just, what was the permit application cost, right? It's what did the effect of the fact that we now have 126 acres of irrigated land versus 126 acres of dry land. How did that change the value of the property?
Sure, and I believe this goes back to what actually occurred in Miller, where it was that one person built the home and basically divided it between three people, and the court awarded all the property to the one individual, and the court said, no, we have to limit that to the actual increase in the value of the property that his efforts did in building the home. So Miller's more of a limitation than a grant to just all the improvement, the value of the improvement to the property. That it's more of a limitation that you actually have to divide this, you have to partition this.
Counsel, I'm curious as to your response to your opposing counsel's argument that it's not just a matter, the increased value that resulted here was not just a matter of applying for this water permit, but it was also perfecting that right by taking some action to actually irrigate the property. So it wasn't just the application, it was the blood, sweat, and equity of actually going in and making some kind of a change. What's your response to that argument?
Sure. So on the purchase of the pivot itself, Kenneth does individually benefit from depreciating that. So it wouldn't be equitable just to award all of that personal property towards the basically crediting for all of that, because he does receive the sole benefit for depreciating that. So that would be my argument there, is maybe it would be equitable to give some of the ditch. I think there was some cost of digging the ditch. Maybe it would be equitable there, but I think that was like about a $2,000 bill compared to where we're talking hundreds of thousands of dollars.
Just to increase my comfort level because of my ignorance about Kansas real property law and water law, do you agree that the permit itself runs with the land and exists in perpetuity so long as it's used?
That's my understanding, but I'm not comfortable saying 100% sure that is true, but that is my understanding.
Okay.
So, and so as the court hinted at before, the issue before the court was whether the installation of the center pivot was the improvement that increased the value of the land. The pretrial orders specifically limited it to that, and the evidence was unanimous that the pivot system did not increase the value of the land. Instead, it was the water permit is what all the appraisers testified to. And then even...
I mean, isn't it in fact, though, that the permit had to be used. And if it wasn't used, it would lapse, and you need some kind of equipment. I mean, I guess unless Kenneth is going to stand there with a bucket and dip into the river and carry it up. It seems to me that the system and the permit operate in tandem as a functionally single thing here for this case. Is that a mistaken notion?
I don't believe that's a mistaken notion, but that wasn't presented before the district court.
You're saying that's not encompassed in the issue as it was framed in the pretrial order, basically.
Correct.
Okay.
And then, as the court indicated, nothing that Kenneth did actually amounted to an improvement as contemplated by Miller. There was no structure made. Like the previous cases all included houses, dams, and fences.
Piping, counsel. I'm curious as to the piping in order to divert that water. Was there any discussion of that?
I'm not aware of any below. Or do you have me asking me for a discussion of?
No, I was curious as to whether that was a factor that the district court took into consideration. And if the court didn't, which is what I understand your answer to be, do you think that that's a factor the court should have taken into consideration?
I believe if it should have been taken in, and if opposing counsel believed it should have been raised as a motion for additional facts and conclusions of law before reaching this court. But if the court doesn't have any further questions, I'll secede the rest of my time.
All right, thank you, Mr. Lohman. Mr. Kirkendall, you still have your 3 minutes of rebuttal.
Thank you, Your Honor. On this last point, there was testimony at the trial on our credit that David Claeys was responsible for burying and digging the trench for the diversion pipeline. That was before the court, and that was something that was presented to him. So he was well aware that the property had been changed by at least this much of an improvement, something that became part of the land because of the efforts of these people. I do want to point to the Kansas Supreme Court case Hazmat versus Certified Waste Services, which adopted a definition of improvements to real property. And that case adopted essentially the Black Law Dictionary of that definition of that term. It's a valuable addition to real property amounting to more than mere repairs or replacement, costing labor or capital, and intended to enhance its value, beauty, or utility, or to adapt it for new or further purposes. Clearly, changing land from non-irrigated to irrigated meets that definition entirely. It changes the use, it improves it, and it makes it much more valuable. Your Honor, the basic equity is the Miller Rule, and it's a premise on this notion that if you spend your blood, sweat, and capital on improving property, that value should come back to you. This is a lesson that has been taught to children for ages. There's the old saying that everything important you learned when you were in kindergarten. I would say that's true in this case. Remember the fable of the little red hen, the bird who found some wheat and wanted to make flour or wanted to make bread. No one would help her. No other farm animal would help her. So she made the bread herself and then was justified when it came around to eating it, to eat it herself. This case is a perfect example of that principle. When it was time to do the work and invest the money to create an irrigation system, the plaintiff and Richard were nowhere to be found. When it was time to reap the benefit of that work through a division of the land, the plaintiff was there demanding her share of the increased value that the appellants, by their own effort, brought about. The court was simply wrong in listening to that demand, granting the plaintiff 1/3 of the value attributable to the increased in value caused by David and Kenneth's investment, granted the plaintiff a windfall, and makes David and Kenneth pay twice to receive the benefit of their industry. For these reasons, Your Honor, we would suggest that the court needs to reverse the decision below and remand for determination of the increased value within the range of the evidence.
All right, counsel, thank you very much, both of you, for your briefs and your arguments. We will get a decision out to you and your clients just as soon as we can. And with that, the court will take a brief recess. Thank you.